We're here today for a change of plea in the matter of the State of Ohio versus Rodney Lee Williams, case number 25 CR 417. Mr. Williams is present today in open court with his attorney, Mr. Jim Matthews. Defendant was indicted on 2 counts, both counts possession of cocaine, each a felony 5 under 2925.11a, count 1 carrying a forfeiture specification. The indictment was filed on May 16th of 2025. Discovery has been sent. The state understands that the defendant is prepared to withdraw his previously entered plea of not guilty and instead plead guilty to count 1 with the forfeiture. We would seek to dismiss the outstanding charge at the time of sentencing, Your Honor. There is no agreement as to sentencing. We would request a PSR as well as a drug and alcohol evaluation.
Thank you. Mr. Matthews, does that sound accurate?
Yes, Your Honor.
And Mr. Williams, were you able to hear what the prosecutor just had to say regarding what he believes your plans are here this morning?
Yes.
He indicated to the court he believes it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to count 1 of this indictment. I'll go over that with you to make sure you understand what that entails. The other count will get dismissed pursuant to the agreement. We would then defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do here today?
Yes.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you, sir?
What?
How old are you?
46.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
I live in a sober living house. No.
Now, that doesn't mean no, but I get it. So nothing in the last 48 hours?
No.
Not even prescribed medication?
No.
Okay. Now, you would have received a copy of this indictment. It looks like you got it sometime right around the beginning of June. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes.
And at some point you had a chance to look that over?
Yes.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to the first count. And what's alleged in this first count is on or about March 21st, 2025 in Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, sir.
Any questions about it?
No.
Now, the charge also carries with it a forfeiture specification, which alleges that you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, whereas an instrumentality is some type of property. There may not be anything illegal about it, but it's being used in an illegal manner or to facilitate a crime, and you can't possess it for that purpose. And here it's alleged that the drugs and any other paraphernalia that was seized during the investigation is the instrumentalities and contraband. The whole point of this is you forfeit any ownership right you have to that property. It doesn't increase any potential jail or prison sentence. It just, you forfeit your ownership interest. You understand that?
Yes, sir.
Any questions about it?
No.
Okay. Now, there is a second count to this indictment, which is being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Any questions about that charge?
No.
Well, then, before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial in this case. The trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. the jurors would consider and weigh that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Having the burden of proof means that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since it's a criminal case, the burden of proof is called a proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge beyond any reasonable doubt before you could ever be found guilty at a trial of this charge. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we did have a trial, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
As the judge questions every detail, the tension in the courtroom rises. Each answer from the defendant brings him closer to a shocking guilty plea that stuns everyone inside.
What you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
And do you still want to plead? Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Not today, but on another day, but you'll be sentenced as a result of pleading guilty. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, are you currently on probation or PRC, post-release control, with any other courts or agencies?
No, sir.
Do you have any of the criminal charges pending against you anywhere?
No, No, sir.
If a prison sentence were imposed in this case, upon your release from prison, you could be placed on what we call post-release control, sometimes called parole. It's a period of supervision you would be on after you served and completed the prison sentence. In this particular case, it could be up to 2 years. It's not up to me to decide, that's the parole authority, but it could be up to 2 years. You understand that?
Yes, sir.
And if you were put on post-release control and you were violating any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir.
And there's also a possible driver's license suspension that I could impose of up to 5 years. Do you understand that?
Yes, sir.
And as I mentioned earlier, any right, title, or interest you have in any of that property that was seized during the investigation, the drug paraphernalia, that'll be forfeited to the state of Ohio. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison's not mandatory or required with these charges. You are eligible for probation, what we refer to as community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you automatically put on probation? It means I will consider that, if that's what you're asking for. I'm going to look at all the information that gets presented. Then I'm going to make the decision that I think is the right thing to do. You understand that?
Yes, sir.
Now, if you are put on probation, it could be up to 5 years of supervision. As the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you are put on probation and you violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. If it wasn't originally 5 years, I could impose more restrictive sanctions against you. I could terminate your probation and send you to prison at that point. If I did it at that point, again, it could be 6 to 12 months in prison. And that could be consecutive to any other prison sentence you may be serving at that time for some new case or that you're being sentenced to at that point. Do you understand that?
Yes.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend and sentence the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all then about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer and have him go over everything with you and answer all your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
What?
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Yes, sir.
All right then, Mr. Williams, any questions for me at this time regarding anything we just talked about? What you're pleading to, the rights you're giving up, penalties you face? Any questions at all?
No, sir.
Do you need any more time to speak with Mr. Matthews before we go forward with your plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what he believes the evidence would establish at a trial if we did have a trial. I want you to listen to him and what he says because I'm going to have some follow-up questions for you about that, all right?
All right.
Mr. Tabache?
Yes, thank you, Your Honor. Were this matter to proceed to trial, the state would show that on March 21st of 2025, Willoughby Hills PD made a traffic stop of a vehicle in Lake County, Ohio. The defendant, Mr. Williams, was a passenger in that vehicle. During the stop, officer called for a canine open-air sniff. That canine did hit positively for the smell of narcotics inside the vehicle. Defendant was then asked out of the vehicle. At that time, one of the officers conducted an exterior pat-down of the defendant's clothing and immediately was able to plainly feel 2 glass smoking pipes inside one of his jacket pockets. Officer also heard the pipes clinking. It was obvious from the officer's training and experience that these were 2 glass smoking pipes typically used for ingesting drugs. In fact, 2 pipes were then pulled out of the defendant's pocket. They contained burnt residue. Search of the defendant's person then yielded a paper bundle with suspected drugs. These items were sent to the Lake County Crime Lab for analysis. At least one of them came back as cocaine, a Schedule II substance. Thank you, Your Honor.
Thank you. Mr. Williams, were you able to hear what the prosecutor just had to say regarding what he believes the evidence would establish at a trial if we had a trial?
Yes, sir.
What, if anything, good to say about those facts as he presented them? Are they true? Did you do what he said?
Yeah.
Very well. Then, regarding count 1, charging with possession of cocaine, a felony in the 5th degree with the forfeiture specification, what is your plea to that count at this time?
Guilty.
All right, I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth everything we've just talked about. Before I can accept your plea, I need to make sure you understand the document and what it says, and that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, sir.
Mr. Matthews, is that accurate? Did you review this with Mr. Williams, read it over with him?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did, Your Honor.
Is that correct, Mr. Williams?
Yes, sir.
So you understand what the document says?
Yes, sir.
Do you have any questions for me about anything set forth in there?
No, sir.
It also appears you signed the document. Did you sign it?
Yes, sir.
Mr. Matthews, you witnessed that?
Yes, Your Honor.
And Mr. Tavanchi, you as well?
Yes, Your Honor, I did.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree, violation of 29-25-11 of the revised code with the forfeiture specification. Count 2 will get dismissed at sentencing. Sentencing will be deferred, however. I'm going to order a pre-sentence report and investigation, drug and alcohol evaluation, and continue bond at $3,500, cash surety or 10%. So what all that means, Mr. Williams, as far as bond goes, first of all, I'm continuing your bond. There's nothing more you need to do about it except to continue complying with the conditions of your bond. One of those conditions is that you don't use any drugs while you're on bond, and you may have to submit urine screens if requested. If they should come back positive, your bond would be revoked and a warrant would be issued. You understand that?
Yes, sir.
Now, the purpose of these reports I've ordered is so I can learn more about you before sentencing. And the way the probation department gets the information they need, they're going to conduct some interviews with you. It's important that when you meet with them and talk with them, you're open and honest with them because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they're going to let me know, and I'll consider that as sentencing. You understand that?
Yes, sir.
All right, so you're going to leave here now. You're going to go to the probation department, fill out some initial paperwork, and get your dates to come back. So make sure you do that when you leave here right now, all right?
Okay.
You know where that is? Or if not, Mr. Matthews will show you
Yes,
where that is. Okay. All right, anything else for the record, Mr. Tavanchi?
With the guilty plea accepted, the judge makes it clear there's no escaping the consequences. What happens next could change this defendant's life forever.